Hello, everybody. It's Walter, your favorite historian, educator, professor, social studies extraordinaire, and blue collar scholar. Today's date is October 17th, 2025. And this video is entitled, The Voting Rights Act is Constitutional. On October 15th, 2025, the Supreme Court of the United States, in the second instance actually, heard oral arguments in the case of Louisiana versus Calais, a civil rights case where it is being argued that Louisiana's creation of two majority black congressional districts in accordance with Section 2 of the Voting Rights Act of 1965 violates the 14th Amendment's Equal Protection Clause because the state, in its overemphasis on race in creating the districts, essentially violates the concept of equal protection and, by a greater extent, thus discriminates against white voters in the state. Now, Section 2 of the Voting Rights Act of 1965 contains language that prohibits state governments from deliberately diluting the power and strength of minority voters in the state. And one way the states have adopted to ensure that this provision is adhered to is the creation of majority black congressional districts. And you will find them throughout the United States, not just in the South. And the individuals who filed this case initially in the lower courts argued, essentially, like I said, that this concept in creating these majority black congressional districts has outlived its usefulness in the modern era. It's now 2025, and such extreme measures to address the issues of racial disparity and unequal representation in voting and the drawing of districts is now no longer constitutional. If the state wants to do this, it has to find another way to do it. To put it in the simplest, non-legalistic terminology I can give you. Now, this decision, if the Supreme Court rules in favor of those who filed this lawsuit against the state of Louisiana, it could have far-ranging effects on the size and structure of congressional districts with respect to minority representation. You will almost certainly see these districts disappear, okay? The blue districts that are in existence in the South will almost certainly become red districts, and minority voting power in these states will be significantly weakened. If the Supreme Court continues along the line of attack that it has been engaging in on the Voting Rights Act since the case of Shelby County versus Holder in 2013, then the Voting Rights Act might become little more than a paper tiger. For sure, to give it a little more context, the Voting Rights Act of 1965 is one of the most successful and potent federal laws in existence designed to prevent racial discrimination in voting. And let's keep it 100% honest here. The law was intended to prevent discrimination against racial minorities in voting, something that was a rampant problem when it was enacted in 1965, signed into law by President Lyndon B. Johnson. For sure, since 1965, you do not see the gross and blatant attempts at racial discrimination in voting that you saw 60 years ago. But make no mistake about it, ladies and gentlemen, states still come up with all sorts of creative, underhanded ways to undermine minority voting. And anybody that suggests something to the contrary is simply wearing blinders. And I'm putting that in the most politically correct way that I can. All right? They're delusional. They're absolutely, positively delusional here. Okay? Ever since the end of the Civil War and throughout Reconstruction and thereafter, states, especially those in the South, have always found creative ways to get around the Constitution and to get around federal civil rights laws. You saw it in the form of poll taxes, grandfather clauses, literacy tests, all sorts of crazy ways. No, they couldn't outright say that black people or Native Americans couldn't vote anymore, all right? But they had to come up with ways that still disenfranchised, or at the very least made it very difficult for these groups to vote with these mechanisms that I just mentioned, and others likely that I have not mentioned, okay? And the same is true in 2025 as it was in 1875, okay? So the Supreme Court has a very tough decision here ahead of it, all right? And an adverse decision against the language of the Voting Rights Act of 1965 and against the existing way that states have chosen to remedy this discrimination by creating majority black congressional districts will have catastrophic effects on minority representation in these states. You will likely see congressional maps throughout the United States thrown into complete and utter chaos with an adverse decision here against the language of the Voting Rights Act, okay? If the court buys this claim that this method of addressing racial discrimination and disparities in voting, then the Voting Rights Act will, in my opinion, cease to be a fluid and functional federal law. Again, Section 4B has already been gutted by Shelby County versus Holder more than a decade ago, leaving all these former jurisdictions free to almost enact any willy-nilly type of underhanded discriminatory measure they want to inhibit voting and minority voting in specific. So people need to wake up here. And it's a shame that this case is not getting the media attention that it arguably deserves, okay? Because the civil rights implications are serious and they are real. Based on the language of the oral arguments, the conservative majority here is all too willing to limit the force and effect of Section 2 in this case. In my humble opinion and judgment, the best we can hope for is that the court rules that the states may still use race, but will have to factor in other types of considerations when drawing these congressional districts. Similar along the legal logic in the affirmative action cases from 2023, all right, where race may still be used, but it obviously cannot be a blatant factor here. It has to be used in conjunction with some other factor regarding the student's development or so forth and so on. But it can't be a determinative factor. All right. That's the best we can hope for. The worst we can hope for, in my humble opinion, is that the court rules that this practice is outright unconstitutional and may no longer draw majority black districts because they are majority black districts and for the sole purpose and intention of creating majority black districts. All right. So we all wait on pins and needles to see how the court will rule in this no doubt landmark decision on Section 2 of the Voting Rights Act of 1965 with respect to these majority-minority congressional districts, which are prevalent in the American South, but again, they exist in many states in general. But I would love to hear your thoughts on the matter, because this is something that affects us all. Leave them in the comments below, and I'll be happy to answer them. We will engage in peaceful, civil discussion. Thanks for listening to this video. Please subscribe to my channel if you haven't already done so. Take care of yourselves. Stay safe out there. Professor Shelton, the Blue Collar Scholar, out.